A routine Chapter 11 bankruptcy case results in a key ruling on recusing a judge.
This is Dr. David Shine, and welcome to Business Law 101.
James Dondero and Highland Capital Management Fund Advisors lost a $180 million arbitration case. They then filed a voluntary Chapter 11 petition in bankruptcy court in Delaware. Shortly after, the creditors committee of Highland moved to transfer the case to the bankruptcy court for the Northern District of Texas on the basis that Chief Judge Jernigan was already intimately familiar with the debtor's principles and complex organizational structure, having presided over two other involuntary bankruptcy cases commenced against other companies where Dondero had also served as an executive. The motion was granted and the case was assigned to Chief Judge Jernigan. The judge then held the first hearing in the Highland case regarding approval of a settlement between Highland and the creditors committee, under which Dondero would surrender his control positions at Highland and be replaced by an independent board. The judge approved the agreed order. Dondero stepped down as officer and director of Highland. He remained an employee of Highland as a portfolio manager until the independent board demanded that he step down. Then Dondero continued to argue for multiple reorganization plans, which were opposed by the creditor committee and the independent board. The judge confirmed the creditor plan. However, the judge indicated that Dondero was a serial litigator and that he did not have a good faith basis to lob objections to the plan. Dondero appealed the confirmation order directly to the Fifth Circuit Court of Appeals, which affirmed the reorganization plan and confirmation order of the bankruptcy court. He then continued for another year and a half to file multiple appeals arguing against various parts of the plan to reorganize the financial companies. 15 months after the case was moved to Texas, Dondero then moved to recuse Judge Jernigan because he claimed that she had developed an animus against Dondero and his associates. She denied the recusal request. Dondero appealed to the Fifth Circuit again. Among his many complaints, get this, was a unique argument that she had published two novels in which he claimed that the financial industry and hedge funds in particular were presented in a negative way. The Fifth Circuit denied the appeal and said of the recusal motion because the Dondero parties had failed to show a clear and indisputable right to relief. So just because a judge writes a book that might show your company's business in a negative light doesn't get you to get rid of the judge. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.